Okay, looks like we have counsel connected, so we'll go on the record now. This is Birdsall versus Dopp, case number 2211282. And if I could just have counsel put your appearances on, starting with plaintiff.
Good afternoon, Your Honor. Evan Pappas on behalf of the plaintiffs.
Thank you, Your Honor. David Busker on behalf of defendants.
Okay, this is set for a status conference today. We set some dates, I think, back in July. Those got extended out by an order back then. The parties did participate in mediation in December, but it looks like unsuccessfully. On behalf of plaintiffs, counsel, can you tell me where things are at from your standpoint?
Yes, Your Honor. We completed facilitation. Although we didn't settle at the facilitation, we are still actively engaged in settlement negotiations. We have completed the lay witness depositions. We're holding off on expert depositions to see if we can get the case settled, just working with each other here. So I guess what our request would be is that we kick the dates out 3 months or something like that to allow us time to see if we can get the case negotiated. If we can, we'll submit the materials to the court. If not, then we'll have some time to notice the expert depositions in the case.
All right, thank you, Mr. Pappas.
Yes, Your Honor. Everything Brother Counsel has said is accurate. We have a good line of communication between plaintiff and defendant right now. I think this case gets resolved informally between the two of us and my partner, Bob Giroux, who's been involved. So if we can get a little bit of breathing room, I think this case will likely settle.
Okay, Mr. Pappas, do you have any objection to the time frame as indicated by Mr. Busker, 90 days?
I do not, Your Honor.
Okay, so I'll just issue a status conference order that reflects that the court will extend all dates out 90 days. I'll set it for another status conference at that point. If the parties submit closing documents prior to that, then we can just take that date off, and if not, then we can see where we're at then. Mr. Pappas, anything further from your side today?
No, Your Honor, we appreciate you working with us.
Thank you, Mr. Busker. Anything further from your side?
That's all, Your Honor. Thank you.
All right, thank you. Mr. Busker, I'll just put you back in the waiting room for the 2:15, and Mr. Pappas, you're free to disconnect.
Okay, great. Have a good weekend. Thanks, everybody.
Thank you. All right, we've got somebody joining on the phone. The last four digits are 2316. Can you tell me your name, please?
Vicky Mrazek.
Mrazek, okay. Ms. Mrazek, if you can just hold on for 1 second.
Okay.
That's it, Mr.
All right, Mr. Mrazek, if you can unmute, please.
Okay,
All right, are you able to hear me okay, Mr. Mrazek?
yes, Your Honor.
All right, thank you. We're on the record now in Mrazek versus Mrazek. This is case number 2311462. The record should reflect that Vicky Mrazek is present today by phone. We have Mr. Mrazek present here today by Zoom video. This is set for entry of a judgment of divorce today. Ms. Mrazek, is that how you wanted to proceed?
Yes.
All right, and Mr. Mrazek, is that how you wanted to go forward today as well?
Yes, Your Honor.
Okay. I'm going to place both of you under oath. I've got some questions that I need to ask each of you. The questions that I'm going to be asking are the questions that I'm required to ask to establish the grounds for divorce under Michigan law. Ms. Mrazek, because you're the party that filed for divorce in this case, most of those questions are going to be for you. So if you can raise your right hand, please, and tell me once it's raised.
It's raised.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Ms. Mrazek, you filed for divorce in this case, and you signed the complaint for divorce. Is that correct?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Crawford County for at least 10 days?
Yes.
In that complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship and that the objects of matrimony had been destroyed and that there was no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
Under the judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
Have you already divided up any personal property between the two of you, or have you reached agreements on how to divide that up?
Yes.
And in the proposed judgment, it indicates that Ms. Mrazek, you would receive the checking account proceeds in the Huntington checking account, and that you would receive the property at Short Street in Grayling, and that you would receive the 2016 Chevy Silverado, and that Mr. Mrazek would receive his 401k funds and a 2007 Buick. Is that correct?
Yes.
And do you agree to abide by that property division?
Yes.
All right, and finally, you're asking to have your last name changed to Anthony, is that correct?
I've changed my mind on that. I'm good with Mrazek.
Okay, I'm gonna cross that out on the proposed judgment then, is that okay?
Yes.
Mr. Mrazek, could you raise your right hand, please?
It's raised.
Thank you. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Mr. Mrazek, did you hear all the questions that I asked Ms. Mrazek?
I did.
Were you able to hear all of her answers?
Yes, I did hear them all.
Do you have any reason to believe that any of the answers she gave were untrue?
No,
Under the judgment of divorce, you also would not be receiving any alimony or spousal support. You understand that you also would be waiving that forever and that you would not be able to come back later and ask the court for that.
I understand.
Okay. And did you hear me discuss those property settlement provisions with Ms. Mrazek?
I did. We had discussed and agreed on those divisions.
Okay, and do you agree to abide by those conditions as part of the judgment?
I do.
Okay, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties in this case. The court has reviewed the proposed judgment, finds that it's generally equitable and contains all the provisions required by statute. The court will grant the judgment of divorce. I signed that today. If either of you would like a copy of that for your records, you can get that here at the courthouse in Crawford County. Ms. Mrazek, do you have any questions at all?
I do not.
Mr. Mrazek, did you have any questions?
No, Your Honor.
Okay, thank you. That's all for today, and both parties are free to disconnect.
Thank you.
Next hearing set for 2 o'clock. We'll be in recess until that time. All right, Mr. Shepherd, are you able to hear me okay?
I can, Your Honor.
Okay, and Ms. Snyder's connecting in here, so we can just wait 1 second.
Yep.
All right, Ms. Snyder, are you able to hear me okay?
Yes, I can.
All right, thank you. We're on the record now in Forefront Credit Union versus Snyder. This is case number 2311489. The record should reflect that we have Mr. Shepherd here present on behalf of plaintiff. Ms. Snyder's present representing herself. Both parties are here by Zoom. This is set for a status conference in this case. On behalf of plaintiff, Mr. Shepherd, can you tell me where things are at here?
Yeah, Your Honor. I think where we're at, and I think maybe why the court maybe misscheduled this is, I think Ms. Snyder and I need to stipulate to a change of venue. From what I can tell, she resides in Otsego County, and that's what she raised in her pleadings. And I tend to agree with her. I think we filed in the wrong jurisdiction. So I do have a stipulation drafted. I just hadn't gotten it to her yet. So that would be my intent, would be to email her at the email address she used with her answer, and then get this off the court's docket and transferred over to Otsego County.
Okay, Ms. Snyder, were you able to hear that?
Yes, I was.
Do you agree with what Mr. Shepherd's saying?
I do agree we need to change the venue, but I'm wondering if some other things can also be filed with that.
Okay, what else would you like?
Well, I had a stroke in August and I am still recovering, so I would like to be 100% in my brain before this actually proceeds, if that makes any sense.
Okay, that does make sense. I think it's probably going to take a period of time for Mr. Shepherd to get this refiled in Otsego County, so that's going to result in a bit of a delay, which would allow some time. And I mean, frankly, the case won't be in front of me anymore. It'll be in front of, or it may be in front of me in Otsego County. I'm also a judge there.
Right.
Or it may get assigned to Judge Hunter. But that would have to be part of that case there. But obviously, Ms. Snyder, I mean, the court's willing to try to accommodate those kind of issues. It's just a matter of balancing that with, you know, the plaintiff's right to move forward.
Right. And I wouldn't mind that, except for I don't have it 100% back yet. It's still somewhat frozen on the right side. And so stuff is not making sense, you know, and I tried to get an attorney, which I would like an attorney so that way I can make sense of everything, because it's, you know, very confusing right now, to be honest with you. So, you know, if I could get I tried to get a court appointed attorney. I'm not sure how to go about that, you know, so that they can interpret or explain things to me that I'm not getting at 100%, you know. It's just frustrating right now, you know, but I am still going through the recovery process, and I just want to make sure we're all on the same page, if that makes sense.
Your Honor, if I may?
Yes.
Ms. Snyder, do you have anybody that's assisting you with your financial affairs currently? Like, do you have a financial power of attorney in place that
Nope.
they could interject? Okay.
No, we did not file a power of attorney because I thought I was fine. And then I had the stroke at a very young age, essentially. So there's nobody that I have in place that can, you know, take over this case, essentially.
You don't have anybody in your life that could assist with that?
Well, I mean, I do. I mean, I could have my husband assist, but we're not attorneys. And so I would like an attorney to actually assist, because the stuff on the paperwork that I got isn't making a whole lot of sense, to be honest with you.
Sure, and I would have no problem with you having an attorney as well, to the extent that for whatever reason that doesn't come to fruition. if there are some paperwork, there's some paperwork that you could sign that could allow your husband to sit in and participate in any of our conversations to the extent that would be helpful to you as well.
Okay. Okay. Yeah, I mean, and that's the only reason I'm asking to extend this out is I'm hoping I would get better and I can get an attorney and things will kind of make sense if that makes sense, to you, because right now I'm like, this just doesn't add up. Like, it's not making sense to me and I want it to make sense if that, makes sense, you know.
Ms. Snyder, have you contacted Legal Services of Northern Michigan there in Gaylord?
I did, and they said they were only doing criminal cases essentially. And I'm like, well, it's not a criminal case. I just need somebody who can, sit in and make sense of it essentially, and then explain it to me. So I know, what's going on. And they said that they don't have any attorneys right now, essentially.
Okay, because I'm concerned maybe you contacted the wrong place because there's an indigent defense firm, Mr. Kilo's firm, and they represent folks that can't afford an attorney in criminal cases. But
Sure.
there's a separate office called Legal Services of Northern Michigan, and
Okay.
they do low income representation for divorces and civil cases like this. So I'm just
Okay.
wondering maybe if you contacted the wrong place.
I'm not sure, to be honest with you. I contacted a whole bunch of different people to try to get somebody, to represent me in this matter. I can try calling legal services, I got a hold of somebody out of Traverse City and they were going to try to get me somebody, in Gaylord who could step in and everything. So I can try calling legal services again and let them know and say, hey, the judge represented or recommended that I call you, to get representation and explain the situation and, see if they do anything, essentially.
Okay, all right. Okay, so Mr. Shepherd, for purposes of today, Mr. Shepherd, if you can submit the order to change venue, and then this will get moved to Otsego County. It'll be assigned up there, and then a hearing will get scheduled. And so I think that's the best way to
Your
go
Honor,
forward.
Do you want me to circulate a stipulation to sign, or are you okay with me just submitting the order to you to change venue?
So I think we've got it. Ms. Snyder indicated she agrees, and I agree. It seems like a proper basis for a change of venue. So I think we've got that for the record. So I think if you just want to submit an order, and as long as it comports, I'll sign that.
Ms. Snyder, I'll email you the contact information for Legal Services of Northern Michigan and Gaylord when we get off the line. Okay.
Okay. Is there any way that when you submit that to Gaylord that we can ask for more time, because that way I can have time to get in contact with them and hopefully my brain will return to normal essentially, because right now it's not back to normal yet, because I haven't been able to work since the stroke happened in August. So, I would like to have some capabilities, back when we talk again. So that way things will make a little bit more sense, if that makes sense.
So Ms. Snyder, what I would recommend is once you get the notice for the next hearing in Otsego County, if you haven't been able to get an attorney by then, that you just submit something in writing similar to what you did in this case, so that if it's a different judge, then that judge can take a look at it. If it's me, obviously I'll already be aware of your circumstances, and then we can work that into how we're going to go forward.
Okay, I would appreciate that.
Okay. Okay, thank you. That's all for today. All parties in this case are free to disconnect at this time.
Okay,
Great.
thank you.
Your Honor. Thank you, Ms. Snyder.
Thank you.
Okay,
I know that's her. I don't know who he is.
all right, folks, you've connected your videos. I'm gonna need each of you to go into your Zoom app and connect your audio, so that I'll be able to hear and talk to you both. Okay, and then sir, you just need to unmute. Can you tell me your name, please?
Anthony O. Saxton.
Mr. Saxton, okay. Ms. Saxton, again, I'm gonna need you to go into your app there and connect your audio. Okay, now you just need to unmute.
Got it.
All right, great, thank you. Can you tell me your name, please?
Anna Saxton.
All right, we're on the record in Saxton versus Saxton. This is case number 2311501. The record should reflect that we have both parties present here by Zoom video. This is a first hearing in this divorce matter. Just looking through the file, it doesn't appear that there's any matters that are in contention, but I do want to just confirm that with both of you. Ms. Saxton, as the filing party here, have you been able to reach agreements with Mr. Saxton and as to how to divide up any assets or debts of the marriage?
Yes.
Okay, from your standpoint, is there anything that remains at issue between the two of you that would require any court hearings or the court to make any decisions?
No.
All right, thank you. Mr. Saxton, from your standpoint, would you agree with that?
Yes.
Okay. So with there not being any issues that need to be decided by the court, I could set this for a final hearing. Ms. Saxton, as the plaintiff, typically you would be the party to do this. There's a form called a judgment of divorce, and you can get that form in the same place that you got the forms to file for divorce. That judgment of divorce is the final document that has to be signed by the court to finalize your divorce. So if you can fill out that form and submit that to the clerk's office before the next hearing, then I can take the testimony I need to take from both of you to establish the grounds for divorce, and we can finalize things at that time. But it's really important that you get that form and then fill it out and then you submit it prior to that next hearing. Otherwise, we won't be able to get things taken care of. Ms. Saxton, do you have any questions about that?
No.
Okay. Mr. Saxton, do you have any questions at all?
No.
Okay. So the court will send out the date and time for that next hearing. It'll be by Zoom, just like we're doing today. And again, Ms. Saxton, as long as you turn in that judgment of divorce prior to that hearing date, we'll be able to finalize things at that time. And you're both free to disconnect. Thank you.
Thank
Thank
you.
you.
Okay, it looks like we've got everybody connected. We'll go on the record in Hamel versus Munson Healthcare. This is case number 2111065. And if I could have counsel put all your appearances on the record, please.
Good afternoon, Your Honor. Albert Dibb appearing on behalf of the plaintiffs.
Good
Thank you,
afternoon,
Your
Your
Honor.
Honor. Oh, go ahead.
David Busker on behalf of the Munson defendants. I believe there's one more defense attorney that may still be getting on.
And James Frisch on behalf of defendants EPMG and Dr. Eden.
Justin Hackala on behalf of Dr. Atchison, Your Honor. Good afternoon.
Good afternoon, thank you. And then I think, was that Mr. Werda, the final counsel? Okay, he's signing on right now. All right, Mr. Word is connected, but he's not connecting his microphone or his camera. So we're going to move forward. I'll give Mr. Word an opportunity if he needs to weigh in on this issue. But we're on the record today for plaintiff's motion. It's plaintiff's motion to amend their witness list. From what I read, Mr. Dibb, and I'm sure you'll fill me in, one of your experts had to withdraw from the case for personal reasons. You're asking the court to grant leave for you to replace that with an additional expert.
Yes, Your Honor.
Okay. Was there anything you wanted to state in support of your motion for the record today?
No, just that Dr. Salzberg had been our expert all along. We were in touch with him. He provided us with an affidavit of merit, which he executed and was filed appropriately, but presently he's not able to continue to participate as an expert. So we were just notified. We filed this motion and we're asking that the court give us some time to secure another expert. I thought I was under the impression when we just finished a deposition of a plaintiff's expert about 20 minutes ago. And I thought we had been in touch with another emergency room doctor, but I was mistaken. So I would only ask that the court allow us some time to secure another expert and substitute that expert accordingly. Thank you.
All right, thank you. I didn't receive any written responses from any of the defendants. I don't know if anyone's opposing this or not. I'm going to open it up since we have so many defense counsel here. For those of you who may want to weigh in on this, I'll just start going in order on my screen. Mr. Busker, on behalf of your side, do you have any objection to this?
No, Your Honor, we didn't file a specific response objecting to it, although we'd like some parameters on the time frame, you know, as long as however long discovery is going, that we still have time to complete it once this expert has been named and deposed, etc.
All right, thank you. Mr. Hackala?
Yeah, we have no objection to adding an emergency room expert for plaintiff, Your Honor.
Thank you. Mr. Frisch?
No, we have no objection. We just asked that there be some sort of parameters. Maybe plaintiff could get us a name within like 7 days and then dates for a deposition within 21 days. Not dates for the deposition, but dates, some availabilities.
Yeah,
Okay.
in response, I would never be able to meet that such a deadline of 7 days, and then a dep dates within 21 days. We'd have to first secure the expert, and that's going to take a little bit longer than 7 days.
Oh, okay.
So that's a little unreasonable. I hasten to point out, Your Honor, that discovery was recently extended. I don't know offhand the cutoff date, but we're in the process now of taking plaintiff's expert steps. And I think we've taken, how many have we taken, Mr. Hackala? 2?
I think we just completed our second.
Three experts. The EMS expert, the nephrology expert, and the OB-GYN expert.
You're right.
And we're still in the process of taking a bunch of others, so I'd ask for a little bit more time than 7 days.
Mr. Dibb, what are you thinking?
30 days to find someone, right? You know, I'll have to send him or her the records for review and for discussion, and then we're happy to, and I can assure the court and the other lawyers that we'll produce him before the end of discovery, of course, for deposition.
All right, I think that's a reasonable amount of time. So Mr. Dibb, if you could submit an order under the 7-day rule, just reflecting the court's granting your motion and that the plaintiffs are to identify the new expert within 30 days.
Thank you, Your Honor, for the accommodation, and have a happy new year.
Let me just address Mr. Werda because he popped in a little bit late. Mr. Werda, we didn't have extensive argument. None of the defendants objected to the motion. Was there anything that you wanted to?
No, Your Honor, and I could hear it all. My apologies for the technical difficulties, and my thanks to Mr. Busker for talking me onto the screen. So I've got no position, no objection to the motion, and again, I apologize for the problems.
Okay, no, I could see you were there. I figured there was something going on.
I had to click OK for the recording up in the upper corner. It was just a little blue button that said OK that I did not click. So that was the issue. I apologize.
Okay, thank you then. That concludes our hearing for today. All parties on this case are free to disconnect at this time.
All right, thank you, Your Honor.
Thank you, Your Honor.
We'll take a short break until Mr. Potter, are you able to hear me okay?
Yeah, I can hear you.
Okay, and is your name Dane Potter?
Yes.
All right, we're on the record in Potter versus Potter. This is case number 2311323. The record should reflect that Mr. Potter is present today by Zoom video. This matter was set for hearing at 2:30. It's now 2:36. I do not see the other party present by Zoom. Mr. Potter, we set this for a hearing today. It looks like going back in July maybe or August, we had a hearing and you both indicated that you were attempting reconciliation, that you didn't want to move forward at that time. We didn't get anything in writing reflecting that. So just trying to find out what the status is, if you both want to go forward with this divorce or whether you want the court to dismiss this case.
I want to go through with it.
All right, okay. So the court will set this for a final hearing date. We already have a proposed judgment that was submitted back in August by the parties. The court will send you notice of the date and time of that final hearing. That'll be by Zoom, just like we're doing today. I'll need to take some brief testimony from you and the opposing party if they appear, and then we can finalize the divorce at that time, okay?
Okay.
Did you have any questions about how we're gonna go forward?
No, how long would that be, or?
That'll be within the next 30 days.
Okay.
And the court will send out that notice by mail, just like we did for today's hearing.
Okay.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
Thank you.
gotta go to work today. Funny.
All right, Mr. Thompson, are you able to hear me okay?
I am, thank you, Your Honor.
Okay, we're on the record in Orr versus Stewart's Northland Homes, case number 2311445. This matter was set for hearing at 2:45. It's now 2:50. It doesn't appear that any of the defendants have appeared today. I do see your client connected. This is set for a notice of hearing to enter a judgment quieting title today. Mr. Thompson, was there anything you wanted to state for the record?
Just very briefly, Your Honor, we're asking for the exact same relief we asked in our complaint. A default was properly entered. We served the defunct corporation according to the Michigan court rules, is why the court entered a default. I have submitted a proposed judgment. The complaint was verified, so I don't know what else the court might be inquiring about. We're prepared to answer any questions the court might have, but we believe there's a sufficient basis to enter this judgment. Thank you.
All right, the court did have a chance to review the file. The plaintiff did properly effect service of the defendants in this case. A default was entered and a notice was provided at the date and time of today's hearing. Again, no other parties have appeared to contest the order. I do have a proposed order here or judgment. Mr. Thompson, is that what you want the court to sign?
Yes, Your Honor.
Okay, so the court signed that with today's date. Anything else I can address for you on the record today?
No, Your Honor, I'll get that original from the clerk and we'll get that recorded. That's where I go from here, but I don't have any other questions for the court on the record. Thank you.
Okay, thank you. That's all for today. All parties on this case are free to disconnect at this time.
Mr. Orr, if you have questions, you can call me directly. Just call the office, okay?
Judge, can you hear me?
Yes, I can. Just trying to determine, got an individual here. Sir, with the hat and the blue sweatshirt, can you connect your audio on your Zoom app, please? While he's doing that, Mr. Gray, I need you to unmute.
All right.
All right. And sir, you're Robert Gray, is that correct?
Yes, Your Honor.
Okay. And Mr. Vernon, you have Miss Gray with you?
I do.
All right, we're on the record in Gray versus Gray. This is case number 2311522. The record should reflect all parties are present for the hearing today by Zoom. This is set both as a pretrial hearing, and then Mr. Vernon, you've filed a motion for a mutual order maintaining the status quo. Is that correct?
It is.
Okay. First of all, with regard to just going forward, can you tell me where things are at from your side and what you'd like the court to do in terms of scheduling to get this case resolved?
So we'd like the court to open discovery and schedule this for mediation. I think I would say 60 days of discovery would be appropriate. Mediation to occur anytime during the discovery. And then we can file motions if necessary after the completion of discovery.
Okay. All right. Mr. Gray, were you able to hear that?
Yes, I heard it.
Do you have any objection to the court setting this to have the parties participate in mediation within the next 2 months, and then if we can get it resolved, have a hearing following that?
Sounds good to me, Your Honor. I'm good with it.
Okay. All right. And then with regard to the motion to maintain the status quo, Mr. Gray, do you have an objection to that?
No, I don't.
Okay. All right. Mr. Vernon, then I'll just ask you, I don't know, did you submit an order with that? I didn't look at the.
I'm sorry, I did not. I have an order prepared, but I thought we were going to be appearing in person, so I apologize for not having submitted that previously. But we'll send it to the group under the 7-day rule.
All right, thank you. So the court will put in the scheduling order that the parties to participate in mediation within the next 60 days, discovery to remain open, and then the court will set it for another status conference at 60 days. If the parties have been able to resolve it, we can use that date to finalize the divorce. If not, then we can see where we're at and what we need to do to go forward. So the court will send out a notice of the date and time of that next hearing. The court will refer this to community mediation. So Mr. Gray, the community mediation service will reach out to you and to Mr. Vernon to get a date that works for everybody for the mediation. And then we'll go from there.
Can I ask a question, sir?
Yeah, absolutely.
If me and my wife agree on selling things, can we sell stuff now or do we have to wait?
If you agree on, you guys can agree on whatever you want to agree on. So as long as everybody's on the same page, then you can do that. And so that's a conversation that you'd want to have with Mr. Vernon. The only thing that the status quo order prevents is from either of you from doing stuff on your own, you know, without notifying or getting agreement from the other party.
Okay, thank you.
All right. Did you have any other questions, Mr. Gray?
No, sir, I don't.
Okay. Mr. Vernon, anything else from your side that we need to address today?
So I just wanted to clarify that the order to maintain the status quo would include any assets that Mr. Gray believes belong to him separately, or any assets that he believes belong to a business entity that was acquired during the marriage or operated during the marriage. We have some Facebook evidence that would suggest that he has attempted to or has in fact sold some property over Facebook Marketplace or some other social media source. And that's the concern we have. We don't want that being done anymore. So it's not just, you know, marital property that, as he understands that, but it's all property until we agree.
All right, well, I mean, I don't wanna, we don't have an order in place, and so there's nothing for anybody to have violated at this point. I don't wanna go down the road of saying somebody's violated something when that hasn't happened yet. So the order will say it'll say what it says, and if either side does anything that violates the order, then I'm sure the opposing party will bring that to the court's attention, and then I'll have to decide whether somebody did or not.
Yeah, but I just wanted to clarify what the scope of that order was intended to be. So thank you.
Okay. All right, I will, the court will send out dates for that next hearing, and we'll go from there. Thank you. All parties are free to disconnect at this time.
Thank you, Judge.
Thank you, Your Honor.
Hearing.
This is the one that he did both village.
Okay, Attorney Katz, can you tell me what case you're appearing on, please?
People versus David Gage. It was set today for a motion to set aside conviction.
Okay, got it. That is, I have that set for 4 o'clock, so I can put you in the waiting room, or you can disconnect and reconnect at that time.
Oh, my apologies, Your Honor. I must have gotten the time wrong. I apologize.
Oh, that's okay. It's never a problem being early, right?
Right. So I will see you at 4 o'clock, sir.
Okay, sounds good. Thank you. Mr. Blumberg, are you able to hear me okay?
Yes, I am, Judge. Thanks.
All right. And are you signing in on Krebs versus Krebs?
Yes, I am.
Okay. And do you have your client with you in your office?
No, she should be coming in via Zoom from her new location downstate.
Okay. I don't see her yet. And then, sir, in the blue hooded sweatshirt, if you're Mr. Krebs, you're going to need to go into your Zoom app. there's a button that you can hit to connect your audio, and I'm going to need you to do that. And then Mr. Blumberg, if you can just remain on the line when I see Ms. Krebs sign in, I'll bring her in as well.
Sure.
Okay, Mr. Krebs, now you just need to unmute, please. Thank you. Sir, can you hear me okay?
Hello.
Hello, on the phone, last four digits 9764. Can you tell me your name, please?
Robert Krebs.
Mr. Krebs? Okay, thank you. Mr. Krebs, I'm going to disconnect you from Zoom at this time and just have you connected by audio, okay?
Okay.
All right, and Mr. Blumberg, I don't see Ms. Krebs joining yet. How did you want to proceed? Can we go forward without her present, or?
Yeah, Judge, I'm sure we can.
Okay. All right, so we'll go on the record. We're in Krebs versus Krebs. This is case number 2311452. We have Mr. Krebs present by phone. We have Mr. Blumberg here by Zoom video on behalf of Ms. Krebs. This is set for a status conference today. We did have a hearing back in December, I think, for a number of different reasons and confusion, and not really the fault of any party in this case. We didn't have anybody appear, so the court reset it for today. In terms of going forward to get the case resolved, on behalf of Ms. Krebs, Mr. Blumberg, do you have any suggestions for scheduling or how you'd like to go forward?
Yeah, Judge, I mean, I think you might recall the parties were both unrepresented at the commencement of this action. I've been in it for a while. I know that there are some unresolved issues. Some real estate issues have been resolved. The marital home has been sold and the parties have divided up the proceeds. Mr. Krebs has a business that is still at issue, along with the issue of spousal support. So I don't know if the parties had already been ordered to mediation or not, but that might be the way to proceed at this point.
Okay, so we did discuss mediation. I don't think they did participate in it. Mr. Krebs, do you have any objection to the court having you and Ms. Krebs go to mediation to see if you guys can reach an agreement on any of the outstanding issues?
Well, the business I did resolve, Judge, I did take a job with, and I'm not hiding anything. I took a job with H&H Tube up in Vanderbilt. I did resolve the business because I ended up losing money during the winter, so I just resolved the business and took a regular full-time job. I just dissolved the business.
Okay, that's fine.
And I do.
But do you, yep.
What's
do you have
that?
any? Do you have any objection to going to mediation to see if you guys can resolve any of the issues that remain?
No, and I don't know why we didn't. I don't know why we didn't do it before. I don't really know why, but yeah, I have no idea because mediation called and something went on, and I have no idea why we didn't settle this before.
Okay. All right. Mr. Blumberg, any objection to that occurring within the next 60 days?
No, that would be fine.
Okay, Mr. Krebs, do you have any objection to that?
No, I don't.
Okay. So the court will refer this to community mediation. Mr. Krebs, somebody from mediation service will be in touch with you as well as Mr. Blumberg to set up a date and time that works for everybody. And then the court will set this for another status conference. If everyone's able to agree at mediation, we can use that date to finalize the divorce. Mr. Krebs, do you have any questions at all?
No, I don't.
Okay, thank you. Mr. Blumberg, anything further I can address for your side today?
I don't believe so, Judge. Thank you.
Okay. All right, the court will send out notices for the next hearing, and all parties on this case are free to disconnect.
Thank you.
Thank you. Okay, it looks like we got both counsel connected. We'll go on the record in Jeffrey Black versus Julie Black. This is case number 2311471. If I could have counsel put your appearances on, starting with plaintiff, please.
Good afternoon, Your Honor. Miranda Bailey Quick on behalf of plaintiff Jeffrey Black, who is present with me in my office.
Good afternoon, Your Honor. For the record, David M. Sanutko, P number 52801, appearing on behalf of defendant, counter plaintiff Julie Black.
All right, thank you. We're on the record today for a scheduling conference in this divorce action. Ms. Bailey Quick, from the plaintiff side, can you kind of tell me where things are at and what you'd like to ask for in terms of scheduling going forward to get this matter resolved?
Yes, Your Honor. I would ask the court for a referral to community mediation. And at this point, there hasn't been a significant amount of conversation, but perhaps we can resolve that with a referral to mediation and just a standard scheduling order.
Okay, Mr. Sanutko, anything in particular that you'd like to request regarding scheduling in this case?
Judge, I would agree. I think a certain amount of discovery here and then a referral to the mediation would be appropriate.
All right, if we left discovery open for the next 90 days with mediation to occur within that time, and then with a status conference following that up. So if there is an agreement, we could use that date as a date to enter proofs, and if not, then we can see what we need to do going forward. Ms. Bailey Quick, any objection to that as a scheduling order?
No, Your Honor.
I would agree with that, Judge.
Okay, all right, great. I will put that into an order and get that out to the parties. Ms. Bailey Quick, anything else from your side that you'd want to address while we're on the record today?
No, I would just ask that mediation occur within 60 days so that if there's additional discovery that needs to occur prior to the end of discovery, that we have an opportunity to do that.
All right, Mr. Sanutko.
Judge, perhaps we could set discovery at 120 days and mediation within 90 days.
Mediation is relatively able to schedule fairly quickly, and I mean, I don't know why we wouldn't be able to, especially with initial disclosures, why we wouldn't be able to exchange within the first 60 days.
I have no objection to that, Judge. We have not had any initial disclosures at this point, however.
All right, I'm just going to order that discovery remain open for 90 days, mediation to occur within that period of time. If the parties want to schedule it earlier during that 90-day period rather than later, I'm sure counsel can come to a reasonable time frame for when mediation should occur. So I'm just going to leave the time of mediation open, but discovery 90 days with that status conference following that up.
Very good. Thank you, Judge.
All right, thank you. That's all I have for today, and both sides are free to disconnect at this time.
Very well. Thank you.
Okay, we have somebody on the phone with the last four digits, 9563. Can you tell me your name, please?
Larry Paxton.
Okay. And sir, you're Mr. Kuznaris?
Yes.
Okay, if you'd like to come forward to that table right there, please.
Yes, sir.
All right, Mr. Jaskowski, are you able to hear me okay?
I'm sorry, Judge. My volume was down. I just turned it up now. So,
sure. Are you able to hear me okay now?
I am. Thank you.
All right. We'll go on the record in Kuznaris versus Paxton. This is case number 2311541. The record should reflect that the appellant, Mr. Kuznaris, is present here in the courtroom today. We have Mr. Jaskowski present by Zoom video on behalf of Mr. Paxton, the appellee. Mr. Jaskowski, Mr. Paxton is connected by telephone. Mr. Jaskowski, this is your motion to dismiss this appeal. I did have a chance to receive your motion and review that prior to the hearing today. Is there anything you wanted to state in support of that?
Judge, I will rely primarily upon the written motion that was filed in this case. Obviously, it is the plaintiff's position that the present appeal is simply a continuation of the ongoing efforts by Mr. Kuznierus to avoid imposition of the order of eviction in this matter. The court rule is very clear, as was the July 12th judgment of last year, that any appeal had to be filed within 10 days. Mr. Kuznierus, of course, has not complied with that. In my motion, I did detail other requirements that Mr. Kuznierus has not met, including even requesting a stay, which was not granted. Notwithstanding that, unfortunately, all of his efforts have been semi-successful for him in that, unfortunately, Mr. Paxton hasn't been able to get possession of his premises that really he should have obtained in October of last year. So it is our request that the court dismiss the appeal. And in light of the lack of merit to the appeal filed in this matter and its untimeliness, we are requesting costs and attorney fees pursuant to MCR 1.109 and MCR 2.625. And those costs would total $845, representing 3 hours of attorney time at $275 and $20 in the motion fee in this matter. I did submit to the court a proposed order. Thank you, Your Honor.
All right, thank you. Mr. Kuznierus, what did you want to say regarding this matter?
Oh, yeah, I understand his thing, but I never received the judgment. Because it was mailed to Roscommon and not in Grayling. So I never received a copy of the judgment.
Okay.
So I couldn't, do anything. I mean, I can show you here where they mailed it to Roscommon.
Okay. What about that goes to the timeliness issue, but there are other requirements for filing an appeal that you're supposed to comply with. And Mr. Jaskowski is saying that you didn't comply with the other requirements either. So what's your position on that?
Well, I didn't know I had, what certain times of the appeal was or anything.
Okay.
I'm just.
Is there a reason why you didn't look into that to find out what you would have to do if you wanted to appeal it?
Well, I tried to get a lawyer, but I couldn't afford one.
Okay.
So then I talked to one lawyer, he would talk to me, and he told me to go get the proof of service, to find out where it was mailed to. And then he told me to get that and bring it to the court.
So there are rules that you have to follow when you file an appeal. There's certain things that you have to file with your appeal, like the transcript, the register of actions. There's a bunch of different things that you have to do if you want to appeal. And if Mr. Jaskowski was appealing, I would require him to follow those rules.
Right.
And so it's only fair that I require you to follow those rules as well. And he and his client have to know those rules and make sure that they comply with them.
Right.
And so I can't just, because you're not a lawyer, I can't say, well, you don't have to follow those rules if they do, right?
Right.
So.
And another thing too, I don't know what I owe. Mr. Paxton gives me one number and the lawyer gives me another one.
Okay. Again, that doesn't really go to what we're here for today, which is whether or not your appeal should be able to go forward.
Yes.
Okay, so other than you didn't know the rules, is there any other arguments that you want to make for why the court should not dismiss your appeal today?
Well, I'd like to save my house. I got 8 years invested in it. And I had the money back in October, but I missed it by 2 days. And I talked to Mr. Paxton. I told him I was going to call him on a Thursday, and he said, okay. So then when I called him, he said I was too late. So I didn't know when the 90 days was up because I didn't get a judgment.
Okay. All right. Well, I mean, where we're at this point, Mr. Kuznierus, is that the district court made its ruling. It found that Mr. Paxton was entitled to get his property back, and that you should be evicted from the property. And so, in order to get past that, you would have to file a proper appeal. You did file the claim of appeal. You know, looking at the final order for eviction, and the date that was entered and the time that you filed your application, I'm not sure that it was necessarily untimely, but there's certainly a lot of other requirements that you need to follow if you're going to pursue an appeal. And it's pretty clear from the record and the file that you didn't properly file all those documents if you wanted to appeal it. And so I can't second guess the district court's decision at this point. I can't consider any legal arguments. Mr. Jaskowski's properly filed a motion to dismiss and pointed out where the deficiencies are, and you know, he's right about those deficiencies.
Yes.
And as I indicated, I would be holding him and his client to all of those rules, and so it's only fair that I hold you to those as well. So I think he is entitled to the dismissal and his request for attorney fees. Mr. Jaskowski, I did have a chance to review the file, and the court still needs to inquire as to, or still needs to make a determination as to what reasonable attorney fees would be. And in my view, looking at the amount of time that would be appropriate in this and the amount that typically would be charged, the court finds that cost of fees in the amount of $500 would be appropriate. So I am going to sign the order as presented with that amendment to it, and the order will reflect that change. I'm just going to handwrite that in.
Certainly. Thank you, Your Honor.
Okay. And the court will have that order in the file today. Mr. Jaskowski, if you need a copy of that. Mr. Jaskowski, anything further for the record today?
Not on behalf of the plaintiff, Your Honor. Thank you.
All right. Mr. Kuznaris, did you have any other questions?
No, Your Honor.
Okay. All right. Thank you. That's all for this hearing today. And Mr. Jaskowski, you're free to disconnect at this time.
Thank you, Your Honor.
And the court.
Thank you, Your Honor.
That's 2 years old. So. Okay, looks like we have everybody connected except Mr. Gage. Looks like he's connecting right now. All right, Mr. Gage, if you can hear me, we just need you to turn on. Okay, now if you can unmute, please. There we go. Mr. Gage, are you able to hear me? All right, we can't hear you, and you're not muted, so that makes me think you don't have a microphone connected. We're still not able to hear you, so I don't know if you're on a computer or some other type of device. If you're on a computer, you would need to have a microphone connected to the computer. If you're on some other type of device, you might just need to enable that microphone.
I do.
There we go.
We heard something.
Now it looks like it's completely frozen up. There we go. Mr. Gage, are you able to hear me?
Yes.
Okay, good. We can hear you now too. And Mr. Gage, if you want, it looks like you don't have a real good signal. You can turn off your video. That sometimes gets us a better signal. It reduces the amount of bandwidth that's being used. And we can see how things go. Let's go on the record. This is People versus David Gage. This is case number 78-264FH. The record should reflect Mr. Gage is present today by Zoom video. If I could have both counsel put your appearances on.
Sierra Coke on behalf of the people.
Good afternoon, Your Honor. Andrew Cates, P78292, standing in for counsel of record and representing Mr. Gage, who appears via Zoom.
All right, thank you. This matter is set today for hearing on an application to set aside a conviction for Mr. Gage back in a long time ago, back in 1974. I have had a chance to review the petition and the supporting documents. And Ms. Cope, do the people take any position regarding the technical eligibility of Mr. Gage to have this set aside?
No, Your Honor.
Okay. So the court agrees that Mr. Gage has met all the technical requirements. The only thing remaining to be decided by the court is whether or not Mr. Gage's behavior and circumstances since the conviction would warrant having it set aside, and that it would be in the public interest to do so. Mr. Katz, I don't normally take sworn testimony, but I do like to hear from either counsel or Mr. Gage or both as to those two remaining factors. So Mr. Katz, however you want to proceed.
I think Mr. Gage might be in the best position to highlight his accomplishments since being convicted. I could do a short voir dire.
That'd be great. Yeah, please.
Okay. Mr. Gage, on or about November 18th of 1974, were you convicted of breaking and entering in the state of Michigan?
Yes, I was.
And as a result of that conviction, did you serve any jail time?
All I served was probation for that.
Okay, and did you complete the terms of your probation?
Yes.
Did you pay all your fines and costs that were due, including any restitution that was?
Yes.
And have you faced any new charges since the conviction?
No, sir.
And if you could just briefly tell the court how has this conviction impacted your life, as far as however it might have impacted you, for better or for worse?
Well, for the hardest part is, at first I was having a hard time retaining work because of my background. I had started, and I moved to Colorado. I started a job with Pepsi-Cola, worked there for 2 years, then went to Coca-Cola, and they did a background check to get me into NORAD, and I couldn't get into NORAD, so I got fired from that job because of the conviction that I had. And then I went and changed my career and started becoming a mechanic, and things were a little easier for me. And was pretty successful at being a mechanic. And the short end of the story is I ended up working for Vail Resorts as a mechanic and become a manager. Spent 32 years there, 24 of them being management for there. And now I would like to get this off of my record if I could. Just to make I'm at almost 70 years old. I'm sure I'm not going to be looking for another job soon, but I'd sure like to have a clean record to live on.
And you said in your affidavit that you have a family. What does your family consist of?
Well, my wife passed away in 2019 from Alzheimer's. I have 2 daughters and a son. They both, my 2 daughters attended college. I put them through college. My son is a highline power worker, and none of them have any criminal records whatsoever. They're good kids.
And you also mentioned that you have grandchildren that you...
Yes, I do have grandchildren. I have 2 daughters, or 2 granddaughters from my daughter, Lindsay. I have 2 granddaughters from my daughter, Carrie. And I have 2 granddaughters from my son and 2 grandsons from my son.
And has this conviction in any way affected your ability to spend time with them, or?
No, sir, it hasn't.
You did mention that there were things that you'd like to do with them, though, that in your affidavit.
Yeah. So my grandson wants me to hunt with him, and he keeps asking me to go hunting. I am too ashamed to tell them of my future. So I just kind of make up excuses why I don't.
So,
Mr. Katz, I think I've got enough with between the affidavit and what Mr. Gage has said. So I think we're good, unless Ms. Koch, do the people take any position in light of what Mr. Gage has had to say here today?
No, Your Honor, the people believe he's met the statutory guidelines.
All right, so I did have a chance as part of my preparation for this hearing to read through Mr. Gage's affidavit, where he expressed the things he indicated here on the record today. I think clearly Mr. Gage's behavior and circumstances since this conviction would warrant having it set aside. He's pursued a successful career. He hasn't had further involvement with the criminal justice system. He's raised a family. I think all of those things show that he's moved well past this prior conviction. He indicated today on the record, as well as in his affidavit, that one of the things he'd like to do is to be able to take his grandchildren hunting, and he's unable to do that because of this conviction being on his record and the prohibition on possession of firearms. And in my view, we need more, not less, people who are willing to take children out and young people and experience the outdoors. And to the extent that Mr. Gage is prevented from doing that because of a conviction from 49 years ago, in light of what he's done since then, I don't think that's a good reason to prevent him from doing that. And I think it's in the public interest that he'd be able to do that in general. So the court finds that he's met all of the qualifications to have this set aside. The court will grant the petition. Mr. Katz, there was a proposed order submitted with the petition, so I'll fill that order out today and sign that with today's date, and that'll be available here at the clerk's office for you to obtain to provide to Mr. Gage otherwise as needed for records going forward. Mr. Katz, anything else we need to address for the record today?
Nothing for the defense, Your Honor.
Ms. Koch?
Nothing, Your Honor. Thank you.
Mr. Gage, did you have any questions at all?
No, sir.
Okay, thank you. That's all for this hearing today. All parties are free to disconnect at this time.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. That also concludes the court.